Welcome to Notable Approvals. I am attorney Amanda Shaffer. I'm not sure if the Instagram is working. Hopefully it is. But before we get to our case today, just a couple of announcements. First, don't forget to like us and follow us on Facebook and YouTube and Instagram and all these places so that you do not miss any of our lives or our other videos. Excuse me. If you find that this video is helpful or you know somebody that may, please go ahead and share it. Also, tomorrow night at 9 p.m. Eastern Time, we'll be having episode 10. Can't believe we're up to episode 10 already. Of Are You Smarter Than a Naturalized Citizen? Attorney Kevin Gregg will be facing off against attorney Charles Kunz. I highly recommend you come. It's a lot of fun, especially if you're studying for your naturalization test. You can get a little bit of taste of what those questions are going to be like. So our case today is an exciting one because it's what we call a 245I case. 245I refers to a section of the Immigration and Nationality Act that you rarely get to use today because there's time limitations, and I'll get to that in a second. But first, a little background here. Client is a native and citizen of Colombia. She first came to the U.S. back in 1996, and she did not have a visa or passport. She entered without inspection. She was a few years old, maybe not even a few years old. She stayed here her whole life. When she turned 18, after she turned 18, she filed for DACA. Now, if you're watching this and you entered without inspection and then ended up marrying a U.S. citizen and wondering, hey, I got DACA, do I need to leave the U.S. in order to become a permanent resident? Well, generally speaking, yes, you do need to. And if you overstayed, or not overstayed, excuse me, if you did not get DACA until after your 18th birthday, then most likely you not only need to leave and come back, but you're going to need an unlawful presence waiver. However, there are certain exceptions. Now, this client has DACA right now. She's renewed every year. She did not have DACA. I don't think she had it since she was 18, but she didn't need to because of this 245I that applies. And again, it doesn't happen very often now because it only deals with certain things that have been filed back in, I think the cutoff dates were April 2000 and 2001. So essentially, either you have to be the principal or the derivative beneficiary of an approvable when filed either alien relative petition, work petition, or labor certification. So basically what this means is that by April, I think it's 30th, 2001, they've had to have received these petitions that were filed back in the day. Now, it doesn't necessarily have to be approved. It gets a little complicated, but essentially all that needs to happen is can be a non-frivolous application. So back in early, 2001, 2000, if a I-130, I-140, or labor certification was filed on your behalf, or you were the derivative, so generally speaking, children under the age of 21 of somebody who had it filed. That's requirement number one. Requirement number two is physical presence. So the principal, so if the petition was filed for you, you're the principal. If it was filed for like your parent and you're on the application as a derivative, you're the derivative. But the principal in this case has to have been physically present in the U.S. on December 21st, 2000. And I'll get to how we show that in a second. So that was something that had to be submitted on top of what we normally submit for a marriage case. Now, in this case, there was plenty of good faith marriage evidence. There wasn't any problem with that. We had joint lease, deposited rent checks as well, joint health insurance, joint car insurance, a joint Verizon bills, I should say, a checking and savings account that were joint that was just open, so we didn't have much, but that was okay because they're still using it. A joint credit card account, We had the petitioner's retirement account, listing beneficiary as the plan beneficiary for the retirement account. We had an affidavit from multiple people, greeting cards, photos, etc. The marriage part was probably our least concerning part of this case. The couple had a very strong relationship and very strong evidence. That's sometimes one of the benefits of having DACA, is that you have a social security number, so maybe it's easier for you to have gotten a lot of these joint documents. So then we also had to prove that she was 245I eligible. And in order to do that, we had to submit a copy of her mother's filed application. So there's different ways of proving it depending on what you have. You know, we're talking about documents over 20 years old at this point. You can do a FOIA request to get them if you don't have them. But we either had to show an approval notice. In our case, we showed a receipt notice as well as the application, and it was stamped on there, received by the Department of Labor, April 30th, 2001. Literally was the last day that could have been submitted for them to 20 years plus later qualify for this 245I. So we had to show that, which we did. We had to show it was approvable and filed. So in this case, the principal beneficiary's labor cert got denied. And just because it got denied doesn't end it. It was denied because the Department of Labor sent out basically a request for evidence to the employer and said, we need more evidence of this, and the employer never responded, and it got denied for a lack of response. However, it was a bona fide application, meaning the position being applied for was legal under the law. They were following everything that she was eligible. The employer just didn't follow through. So the whole point is not to harm somebody down the line because of something out of your control. Because remember, you're not the petitioner. You're not the one who can respond in any of these things that can make you 245I eligible, whether it's based on family or work. You're not the petitioner. So if someone doesn't reply, they're not putting it on you. And again, this law is limited. There is a cutoff. So in addition, our client had to be under the age of 21 on April 30th, 2001, which she was. And then the hardest requirement for a lot of people with the 245I usually is showing the principal. So not our client, but her mother, the person who the labor cert was filed for, we had to prove she was physically present in the US on December 21st, 2000, not the year 2000, not 2000 and 2001, on that date. Now, that can be very difficult to show, especially when it's that long ago. In this case, we did a really good job of showing it. We showed her mom listed as the emergency contact on her on the daughter's school records from starting in 1996 through high school, which passed 2001. Then we had a federal savings passbook with a deposit before the 21st of December, but also on December 22nd, 2000. So it was almost dead on point, but it was after, so that's why we include some extra stuff. We also put in an affidavit from her mother saying she was physically present, as well as 3 people who knew her back then, including a neighbor, an employer, and her husband. And all of that together, we were able to show. There's also an extra $1,000 filing fee you must file to be 245 eligible. So with all of that and the extra filing fee, we showed that our client was certainly 245 eligible, and it was just a matter of her having her interview, and everything went great. The I-130 was approved immediately, as we expected, and of course, we weren't surprised when they need a little bit more time with the 245I, because a lot of the USCIS officers these days haven't dealt with it much, if at all, because it's so rare when it comes across. For us, it's one of our favorite things, because you have a client come in who thinks that they're not going to be able to get a green card at all, or they're going to need to leave the country to get one, or they're going to need to show an extreme hardship to a relative. And then we ask all the questions, which one of them is, any chance that something was filed for you or like a parent back in 2000, before 2000, 2001. And every once in a while you get a yes. And it's really exciting when it happens because it completely changes how we're going to do the case, and it makes everyone's life so much easier. So that is all today for notable approvals. Again, if you find that this is helpful, please share with others, or know someone who might be 245I eligible, reach out to us. Also, we have a lot of clients who have DACA that end up getting married and adjusting their status, so we can certainly help with that as well. Please feel free to contact us. Our contact information is scrolling along the bottom of your screen. Don't forget to like us and follow us on Facebook, YouTube, LinkedIn, Instagram, all that. And don't forget, tomorrow at 9 p.m. Eastern Time, we will be having episode 10 of Are You Smarter Than a Naturalized Citizen? 2 more attorneys will face off to see who can pass the naturalization test first. This is our first and probably only back-to-back show weeks. We had a great show last week. We are gearing up to have a great show this week, so I invite you all to tune in. And that is all for now. Thanks for watching and have a great day.